Sharing my PPT for everybody's interest. So we are discussing about directors of the company. Yesterday we had a few points. Very few students attended the classes. Okay. So I'll be just minimizing this so that we can proceed. So we discussed about appointment of directors, removal of directors also. And the most important part of our examination questions is duties of directors of a company. So there are several duties to be performed by every director of a company. So there are certain statutory duties, there are certain general duties. Okay. So I'll be discussing about the sections also. If you can note down, you can note down the points. So under the Companies Act 2013, the duties of a director are explicitly defined for the first time in section 166. As I was discussing prior to this, there were no specified duties, but there were certain general duties. And these duties were largely derived from judicial pronouncements and common law principles. So the new act codifies these duties, making them legally binding and providing a clear framework for directorial conduct, what they are supposed to do, what they are not supposed to do. Everything is clearly mentioned. So section 166 clearly states about the duties of the directors. So section 166 subsection 2 specifies the duty to act in good faith. Every director should act in good faith towards the company. Why? Because the director has, the company has appointed a director keeping a lot of confidence in him. In the same way, the director also has to show his faith towards the company by his behavior, by his acts. So, a director must act in good faith to promote the objects of the company. So, there are two types of objects. One is main objects, second is other objects. Main objects are those objects which are specific and which remains until the company is wound up. The other objects may change from time to time depending upon the circumstances. Sometimes we have seen that there may be changes in law. If the law changes, the objects also must be changed. So in that case, we call them as other objects. So the main objects remain from the date of incorporation till the closure of the business. So a director must act in good faith to promote the objects of the company. And this duty extends to the benefits of its members as a whole. Once we understood that a director himself is a member, why? Because he has to purchase minimum qualification shares. So he becomes the member and he also has to perform all his duties for the benefit of the members of the company. It also includes a responsibility to act in the best interests of the company. That means, because the company appoints him, he has to act in good faith towards the company. He also act towards its employees, company's employees. Yesterday we understood a director may act as an employee. Why? Because he has different positions as an agent, as an officer, as a trustee, as employee. Okay. So the director, being an employee, should also act in good faith towards the other employees in the organization, in the company, and the community. Here, what does the community mean? The society in general. So when he is acting in good faith towards the company, automatically he will be acting in good faith towards the community also. Why? Because the company may be involved in producing the goods or rendering the services. When it is producing the goods, it has to produce qualitative goods which are beneficial to the general society. Similarly, if they are rendering the services, it should be to the utmost satisfaction of the community in which the services are being rendered. then he also has to be very responsible to protect the environment. So nowadays, protection of environment is very, very important. We have ESG, environment. What is ESG, students? Environment, society, and governance. Okay. So protection of environment is very, very important. So we have seen recently in the northern part, because the people have neglected the environment, there were heavy floods and the people lost their lives and properties also. So wherever there is non-protection of the environment, then there will be a lot of problems to be faced. So the director also should be responsible towards the protection of the environment. Next, duty to exercise reasonable care, skill, and diligence. This is as per section 166, subsection 3. So a director must exercise his duties with due and reasonable care. What kind of care he has to say? Reasonable care means the care as much as possible as he takes for his personal benefits. That becomes a reasonable care. And he must perform his duties with due and reasonable care. And if he has skills, professional skills, technical skills, or any kind of skills, those skills also must be used. Some people are very good in communication skills. Based on their communication skills, people win the hearts of others. Similarly, if one has a technical skill or any kind of skill, he must exercise or use in the company for the benefit of the company. And he must also act diligently, carefully. Okay. And this includes exercising independent judgment. So even though he takes the decisions for the benefit of the company, he should also exercise independent judgment. Sometimes he may have to reveal, sometimes he may not have to reveal, but it must be unbiased. Okay. The standard of care is that of a reasonably prudent man and may be higher for a director who is an expert in a specific field. As we are discussing, whatever the domain in which he is appointed, so he will be generally an expert, and in his field, whatever the care to be exercised, such care must be initiated. And the next duty is duty to avoid conflict of interest. Generally, there will be conflict. What is the general meaning of conflict? Anybody? The general meaning of conflict is difference of opinion. Okay. So here conflict of interest means the rules of the company are framed. The expert, being a director, should be having some knowledge relating to some field. So his knowledge and the rules relating to the company should not have any conflict. If he has a conflict, what is the superior? Company's rules and regulations are only superior. So he has to avoid conflict of interest. He is personally interested, but what is a subordinate? His interest is subordinate. Okay. So a director must not involve in a situation where they may have a direct or indirect interest that conflicts or possibly may conflict with the interest of the company. So this is a fundamental fiduciary duty. We already understood. Fiduciary means having trust and confidence. So the director must ensure their personal interest do not override their duty to the company. Okay, this is another one. Next, duty to not achieve undue gain. That means they are not supposed to make any secret profits. This is specified under section 166, subsection 5. A director must not achieve or attempt to achieve any undue gain or advantage, either for themselves, their relatives, partners, or associates. For that reason, the Companies Act also has defined the word relative. Who is a relative? Who is not a relative? Suppose I am director of a company, I cannot appoint my daughter or my son as additional director or deputy director or alternate director in whatsoever. So because he is blood related, she is blood related. So they come under a relative definition. Okay. So if there is a long relation also, there is some kind of blood relation connected. So they should not be entering into contract with the company, and the director should not allot any kind of contract to such persons, because there will be some advantage they will be gaining through the company on behalf of the director who is appointed. Similarly, partners or associates. So there should not be any kind of gain that they have to get through the contracts of the company. So if a director is found to be in contravention of this, they are liable to pay an equal amount to that gain to the company. Whatever the benefit they have received, they have to surrender back to the company. Okay. So this is duty not to achieve undue gain. Next, duty to not to assign office. Suppose these days what happened, some people who are not able to do their job, they are assigning their job to some other people. In that case, people may not do justice in performing their duties. So, director should not assign his office to any other person, cannot assign their office to any other person. Any assignment made by a director is void. Why? Because other people also may have some kind of personal gain. So all such contracts become void. This ensures that the responsibility and accountability of a director remain with the person appointed to the position. So a director should not assign his office to any other person. Duty to act in accordance with the Articles of Association. Section 166, subsection 1. So a director must act in accordance with the company's Articles of Association. Why? In Articles of Association, all the details relating to appointment of a director, removal of a director, then duties of the director, then liabilities of the director, remuneration of the director, everything will be disclosed. So he must act in accordance with the company's Articles of Association. So the Articles of Association serves as the internal rule book for the company, and the director's action must be within its confines. That means he must not go beyond the rules specified in the Articles of Association. Then there are certain additional duties which are implied by the Act. Okay. So Section 166 provides the core duties. The other sections of the Companies Act impose the additional specific responsibilities on directors. What are they? Just a minute, students. Hello. చెప్పండి. బాగున్నావా సాయి? చెప్పు బాబు. ఓకే ఓకే, ఇంప్రూవింగ్. యా, వస్తారు ఈరోజు, ఆంటీ వస్తారు. షీ విల్ కమ్. రైట్. Okay, so are you able to hear me, students?
Yes, sir.
So there are some additional duties which are specified other than Section 166. So duty to attend board meetings. All the directors put together is called board, and information will be given to attend the meetings. So it becomes the duty of the directors to attend the board meetings, whether he is interested personally or not, because he is a director and he has to protect the interest of the shareholders. He has to attend the board meetings. Directors are expected to attend the board meeting. Failure to attend all meetings for a continuous period of 12 months without leave of absence results in automatic vacation of office. Generally, there will be 4 meetings. Each meeting will be held for a quarter. Suppose if he is continuously absent for 3 board meetings without any information, then he may not be attending the fourth meeting also. Thereby, in a period of 12 months, if he does not give any information about his absence, then he has to automatically vacate his office. This is specified under section 167. Next, duty to disclose interest. If he has any interest towards the company with more ideas, then he must disclose what gives benefit. So you see, there are so many companies. Some companies come up with new ideas, and other companies may not. So all other companies will be following if a new idea generated by a company is good for the society. So if any person who is occupying the position of a director has an interest towards the company and the benefit of the society, then he has to disclose his interest. So a director is concerned or interested in any contract or arrangement with the company must disclose the nature of their interest at a meeting of the board. This is specified in section 184. And the next is duty to maintain books of accounts. Directors, especially the managing director. Yesterday we understood kinds of directors. So managing director and whole-time directors have a responsibility to ensure that the company maintains proper books of accounts and prepare financial statements as per the act. So yesterday we understood what are the accounts that are to be prepared and what are the financial statements to be maintained. Okay. And the duty to not accept remuneration for holding an office of profit. A director cannot be holding any other position for benefits, his personal benefits. Once he is a director, he cannot accept any other office. So a director of a company is not permitted to accept an office or place of profit in the company or its subsidiary without the prior approval of the company in a general meeting. This is also discussed in section 188. Okay. So what are the additional duties? Duty to attend board meetings, duty to disclose interest, duty to maintain the books of accounts, duty not to accept remuneration for holding an office of profit. Okay. Then there are certain liabilities for breach of duty. We understood breach means failure. If a director is failing in performing his duties, then they are also specified in section 166. So there will be a penalty. Section 166 subsection 7 specifies a director who contravenes the provisions of section 166 is punishable with a fine of not less than 1 lakh rupees and which may extend to 5 lakhs rupees. Okay. Once a person has failed to perform his duties, then we understood duty to act in good faith. So once he is failing in his duty faithfully towards the company, then he may be removed. Okay, sometimes. Liability to the company. In addition to the statutory penalty, a director can be held liable to the company for any loss or damage caused by their negligence, breach of trust, or ultra vires. Ultra vires means beyond powers. Okay. So the acts of the directors may be beyond the powers. So even that they do not have powers, they may appoint. So we understood in one case in business law, one person will be applying for the post of a principal in an organization. So there will be board of directors. So one of the directors who knows attending the interview has privately informed the other person that you are selected. But the company directors were not interested in that person and have not approved his selection. So accord is a word which is used where there will be total approval with their complete knowledge. So they have not accorded. And as he has privately informed and the selection was not made, he moved to the court of law. So duty to be informed. Okay. So one should not cause any kind of loss due to their negligence, breach of trust, or ultra vires beyond the powers. Okay. So these are the liabilities for breach of duties in respect of duties. And there are other liabilities which we have to discuss, and these liabilities sometimes may be asked for 4 marks or sometimes maybe for 10 marks. So for 4 marks, you have to write in brief. For 10 marks, you have to elaborate. Under the Companies Act 2013, the liabilities of a director are extensive and can be categorized into 3 main types. One is civil liability, second is criminal liability, and third is personal liability. The Act has significantly broadened the scope of a director liability to ensure greater accountability and transparency in corporate governance. Okay, yesterday we understood about corporate governance. So in Information Technology Act, we are going to learn about e-governance. Okay, so what are the civil liabilities? Civil liabilities typically involve monetary damages or other forms of compensation for a loss caused by a director's actions or negligence. So we understood the director must act with a fiduciary term. So when he does not act fiduciarily, then he will be liable to the company. Okay, so this becomes the civil liability. A director is a fiduciary of the company if they breach their duty to act in good faith and for the company's best interest. They can be held liable to the company for any kind of loss that is resulting. So it may be of misusing company assets, maybe making personal profits from corporate opportunities without a disclosure, or engaging in a conflict of interest. So we understood there may be some interest, so that interest must be continued. If there is a conflict interest, his interest is subordinate and rules of the company are superior. And next liability is liability for ultra vires. We already understood ultra vires means beyond the powers. An act is ultra vires if it is beyond the powers of the company as defined in its memorandum of association or beyond the powers of the board as defined in the articles of association. I think in your memorandum of association chapter, you have learned that the directors cannot act beyond their powers. So there is a case. In England, there will be tramways. Tramways are the railway routes on the road itself, tramways. So the company was a railway company and they were permitted to lay tramways, for which they have to enter into contract. So railway company cannot do, so it has to enter into a contract. So they have invited for tenders. So people have applied, and one person who is a director of the company, without the knowledge of the other directors, has permitted to lay tramways. So when he is permitting to lay tramways, he must also should have knowledge whether the government has permitted to lay tramways in that particular route or not. Yes or no? So he has already permitted, and the contractor started working on it. The government denied laying tramways in that particular route. Therefore, the contract could not be completed. So they made an inquiry. Upon such inquiry, it was found that a director has given a green signal to lay tramways in that particular route where the government has not permitted. So this becomes ultra vires. Okay. So recently, our Telangana government also is planning to have 3 terminal stations. Already one is in Charlapalli, the other one is towards Medchal, and the other one is towards the Shamshabad. So like that, at 3 places, they want to have terminal stations. Why? Because there is heavy traffic in the 3 stations, major stations in Hyderabad. Nampally railway station, Secunderabad railway station, and Kachigura railway station. So if the railway company makes any power or draws any kind of contract in favor of a person, if the government has not permitted, then it becomes ultra vires. Okay. So the directors who authorize or perform such acts are personally liable to the company for any loss incurred. So These are civil liabilities. Next, another liability is liability for fraudulent trading. Yesterday we understood oppression and mismanagement. So people may not disclose the information to small shareholders, and thereby the directors may be interested to have their trading for their personal benefits. So some of you may be involved in trading activity, okay, stock trading. Any of you know about inside trading? Students, anybody knows? So because of inside trading, most of the directors were getting personal benefits. And after that, the SEBI has blocked insider trading. Okay. Liability for fraudulent trading. This is specified in section 339. In a winding up process proceedings, if it appears that any business of the company has been carried on with the intent to defraud creditors or for any fraudulent purpose, the National Company Law Tribunal can declare that any director involved in the business is personally liable for the company's debts. See, so this rule says at the time of winding up of the company, but in general also, when things happen, everybody who is interested in the company may come to know and they may apply to the central government. So the National Company Law Tribunal may declare that person to be paying liability. Okay. So the liability for misstatement in prospectus. We all know what prospectus is. Prospectus is a statement, a circular, an invitation, a pamphlet inviting the public to subscribe for shares. And all the information which is furnished in the prospectus must be true and correct. There should not be any wrong information. That is the reason why Companies Act has specified that the golden rule must be followed. Once you specify any point in the prospectus, that becomes the golden rule. And if any director involved in giving wrong statement about the company or on behalf of the company, then the directors are liable. So we call it as liability for misstatement in prospectus. This is specified in section 35. So the directors who authorize the issue of a prospectus containing a misstatement are liable to pay compensation to every person who subscribed for shares or debentures on the faith of the prospectus and has sustained any loss or damage as a result. This is a significant liability as it can be invoked by any aggrieved investor. Okay, this is one. Next is liability for undue gain. Already we understood if there is a personal gain, he must surrender back to the company. So as per section 166 subsection 5, if a director achieves any undue gain or advantage for themselves or their relatives or partners, they are liable to pay an amount equal to that gain back to the company. So they have to surrender back. Okay. So these are few liabilities. So just a minute, students. Okay. So we have discussed about civil liabilities. Now we will be discussing about criminal liabilities. So the Companies Act 2013 has specified that certain fines which are laid in civil liabilities may not be sufficient for certain acts which are categorized as criminal acts. Now, what is crime? Anything which is causing some kind of loss to the company, loss to the shareholders, that becomes the criminal act. Okay. So in what form they can be treated as criminal acts? So criminal liability is specified that liability for false statement makes the director liable. So if a director knowingly makes a false statement or omits a material fact in any document written. What is this written? Annual return or report, annual report required under the Act. They can be held liable under Section 447, the penalty for fraud. Section 447, penalty for fraud. And the penalty can include imprisonment for a term of 6 months to 10 years. A very long period, you see. False statements. Now, what are the statements that the company has to prepare and submit? One is income statement. Second is position statement. Third is, hello.
Cash flow statement.
Yes, very good. Cash flow statement. Fourth one is funds flow statement. Last one is statement of retained earnings. So in all these statements, even if one statement contains a false information, then the imprisonment term may extend from 6 months to 10 years period, and a fine that can be put to 3 times of the amount of the fraud. Okay, so as per the kind of fraud that is committed, as per the loss that was sustained to the company, 3 times of such loss will be penalty. Okay, next is liability for fraud. We already understood fraud is an intention to deceive the party, here the company or the contract. The Act's definition of a fraud is very broader. Any act, any omission, any concealment of a fact by a director with the intent to deceive is considered fraud. This can result in severe penalties. Okay. Now, what kind of frauds may be possible? Okay, non-compliance with the statutory duties, failure to hold annual general meeting. We understood annual general meeting must be conducted every year within 12 months period. If the meeting is not conducted, they may obtain permission from the registrar of companies for an extended period. Even after the extended period, if the annual general meeting is not conducted, then it is said to be non-compliance with the statutory duty. So failure to hold an annual general meeting as per the Act's provisions can lead to fines for every defaulting director. Okay. So we have understood yesterday that the director acts as an officer. So he will be called as officer in default. So failure to maintain books of accounts. If a director fails to ensure that the company maintains proper books of accounts, fails to ensure that the company maintains proper books of accounts, they can face imprisonment or fine. This is as per section 128. Then failure to file financial statements or annual returns. So mere preparation of financial statements or books of accounts is not sufficient. They must be submitted to the concerned authorities. Okay. So this is a serious offense that can lead to fines and even a director disqualification. This is as per section 164 subsection 2. And liability for winding up. In the event of winding up, directors can be held criminally liable if it is found that they have engaged in fraudulent activities, such as transferring company's property with the intent to defraud creditors. So this is a very serious liability on a director. Okay. So we understood civil liabilities, criminal liabilities. Now personal liabilities. In certain circumstances, the corporate veil can be lifted. What is the exact meaning of corporate veil? Corporate veil is something like separate entity. Company is different, companies, directors are different, and the directors can be held liable for the company's debts. So, how the company's debts would arise? Due to the acts of the directors or not? Okay. When the corporate veil is lifted, the act provides instances where a director's limited liability is removed. This is very, very serious issue. For example, if a director signs a negotiable instrument or like a promissory note or a check on behalf of the company without properly mentioning the company's name, they can be held personally liable. Generally, what happens whenever they issue a check or whenever they write a promissory note, they will put a stamp. Earlier, they were writing. Okay, sometimes some people's handwriting is very horrible. God only can save them. So in order to avoid that, they said at least you affix in the form of a stamp so that it is legible at the time of encashment. Okay, so the concept of lifting the corporate veil can also be applied by the courts in cases of fraud, tax evasion, or when the company is used as a mere cloak for an illegal activity. Okay, so when corporate veil is lifted, they are personally liable. Next, liability of a defaulting officer. So we understood in case of public company, there will be a minimum 3 directors and a maximum of 20 directors. But in case the other directors are not interested and few directors are interested and they want to perform all the acts, in that case, they may have to declare them as defaulting officers. Just a minute. क्लास चल रहा है आ जाओ बैठो थोड़ी देर बैठो आ जाओ but take that chair and sit down. Take the chair, no problem. Good afternoon. Chair ले लो, वहां से chair ले लो, अंदर से ले लो. Okay, so if a person is acting only in favor of the company or in any kind, then such persons will be called as officer in default. So for such officers in default, they will be held liable. Take this chair, no problem. Okay, so this is very, very important and this may be asked in examination. What are the liabilities of directors of the company? Okay, na? I think you may be visible. Okay, otherwise you pull that chair that side. Okay, few minutes. Okay. Next and most important point is remuneration of directors of the company. Remuneration is very, very essential. So without remuneration, the directors also will not show any kind of interest to perform their duties. So the remunerations are paid. Yesterday we were understanding whether the commission is to be paid or remuneration is to be paid. So there is a clarity and there is also a conflict of interest in the minds of the directors of the company. Why? Because commission is paid for the acts done by the manager. So if he is a sales manager, then commission is paid. But what about the other directors? Remuneration shall be payable. So when we are doing financial accounting problems, we see that the commission is paid. When we are discussing about the Companies Act, we say that remuneration is payable to the directors. Both are correct, but at the same time, in their respective contexts, remuneration to the directors of the company and commission to the manager. Okay, so their commission is payable on the profit. So here remuneration is payable on the net profits of the company, but there is a restriction. Okay, so under the Companies Act 2013, the remuneration of directors is governed by section 197 along with other related sections like section 198. The act provides a detailed and more restrictive framework for directors remuneration compared to the previous act. Okay, so there should be transparency when they discuss about the remuneration payable. So we discuss there is overall managerial remuneration. When the overall managerial remuneration is paid, all the directors put together, when the remuneration is calculated, then we call it as overall remuneration. So we discussed directors, alternate directors, additional directors, deputy directors, and directors in case of casual vacancy. So all these people put together, the remuneration is paid. So we call it as overall managerial remuneration. This is discussed as per section 197. So this cannot exceed 11% of net profits of the company for that financial year. So we calculate net profits. Now, how net profits are calculated is discussed in section 198. So the net profits for the purpose of calculating remuneration must be computed in a specified manner. So what is that? Certain items such as profit on sale of the undertakings or immovable properties, capital profits and premiums on issue of shares, issue of debentures, okay, and it includes items like bonuses, commissions and other perquisites. So all these may not may be covered under section 198. Okay, so this is how the remuneration is payable to the directors. Okay, so what is the remuneration for different types of directors? So we have managing director, so we can pay up to 5%. And if there is more than one such director, so we already understood there can be one managing director or one whole-time director. So they cannot be both managing director and whole-time director. Why? Because the whole-time director will be performing his duties as a full-time employee, and the managing director will be performing the duties as executive director. So therefore, either one of them should be appointed or one of them should be there in a company. So a company can pay up to 5% of its net profits to one such director. If there is more than one such director, the total remuneration payable to all of them cannot exceed 10% of the net profits. Similarly, for non-executive directors and independent directors, it cannot exceed 1% of the net profits if there is a managing director or whole-time director. If there is no managing director or whole-time director, this limit can be increased up to 3%. It can be only 1%. If at all it is to be increased, it can be increased up to 3%. This is very, very important, students. Keep this in mind. When the managerial remuneration is asked in 4 marks, you have to specify all this. Okay, na? So just we hold it for a minute, students. We hold it for a minute, just a minute. So we were discussing about the liabilities of the company, and we were also discussing about the remuneration of the company. Okay. Now, when we are talking about remuneration of the company, it cannot also exceed a particular limit. So if it has to exceed, if it wants to pay the remuneration more than the specified limit, then it has to pass a special resolution. Okay. And it will be a general meeting, but a special resolution is required. So central government approval is also no longer required. Why? Because the special resolution is passed in the meeting. So under the Companies Act 2013, the requirement to obtain central government approval for remuneration exceeding the limits has been done away with, streamlining the process. However, a special resolution of the shareholders is mandatory requirement. So after this special resolution is passed, then there will not be any problem. Then what are the components of remuneration that are paid to the directors? One is sitting fees. A director may receive fees for attending board meetings or committee meetings. The maximum sitting fees that can be paid to a director is 1 lakh rupees per meeting as per the rules. See, when we are discussing about board meetings, we already understood that a company may conduct 4 such meetings, each meeting at each quarter. So if the directors are attending, they must be paid sitting fees, which may go up to 1 lakh rupees per meeting. Then commission. A director can be paid a commission on the net profits of the company. This is what we were discussing. Is that the remuneration or a commission? Okay. Then perquisites, benefits. This includes the value of a house, car, medical expenses provided to the director, and sometimes salary. When the salary is paid, when the director is acting as an employee, director is acting as an officer of the company, salary is paid. So this is typically applicable to managing directors and full-time directors. So these are the components of remuneration which shall be payable to the directors of the company. So if there are inadequate profits or sometimes no profits, can we stop paying the remuneration? That is specified in Schedule 5. If a company has inadequate profits or no profits in any financial year, the payment of managerial remuneration is governed by Schedule 5 of the Companies Act 2013. Board resolution and shareholders' approval is essential because who are appointing the directors? Shareholders are appointing the directors. Okay. And who will be taking decision? Board will be taking decision. So the payment of remuneration in this case requires a board resolution and a shareholders approval. So the limits on remuneration are specified based on the effective capital of the company. But any kind of payment that is to be made cannot be paid out of its capital. This is very, very important. And disclosure requirements, very, very important. Every director has to disclose necessary documents. So if we look at the website, I will show you if possible. If possible, I will show you. As we are online, I will show you. So you mention any name of the company? Let us take this. Okay, now? So here you see on this website, you have about the features of mobility, organization, history, leadership, okay, and then business, whichever its business is, corporate responsibility, ESG is there, you see, investors, what type of investors are there for this company are also specified, careers, okay. And apart from this, there will be some information mentioned at the end, okay. Now you see this, we have it's not appearing here. Let's say in the Tata Motors disclosures, Tata Motors disclosures, you see. So, as per SEBI guidelines, these are the details which should be disclosed. Okay, na? So, these disclosures are mandatory. And you see, whistleblower policy is also there. Okay. So, I was looking at this place, but I was planning to search it fast. Okay, na? So, like this, there may be possibility of making disclosure, and if the directors have not disclosed the details, then they will be held liable. So, it is mandatory. So, what are the board report? The board of directors report must contain a statement showing the remuneration paid to the directors. So, in the statements also it will be available. So, as per section 197 subsection 12, this enables transparency, and the remuneration policy also should be specified. The board of a company is required to formulate a policy on the remuneration of directors, key managerial personnel, and other employees. This policy must be disclosed in the board's report and on the company's website. So, there may be refund of remuneration also. If a director receives any remuneration in excess of the prescribed limits or without the necessary approvals, they must hold the amount in trust for the company and refund it within 2 years of receiving it. Okay. So, the company has to recover the excess amount. So, these are the points relating to directors liabilities. Okay. So, shall we move forward to the next topic? Next topic is meetings of the company. This is very, very important from examination point of view. So, my dear students, you understand the Companies Act will have these two in the unit 4. First part of directors, there will be a definite question. Second part is meetings, that will also have some questions, 4 marks questions and 10 marks questions. Now, we know people meet for some purpose. Then the company also conducts the meetings for some purpose. So the meaning is mentioned in the Companies Act. In the past, the meaning was not meaning was not specified, but new Companies Act has specified. You see, the Companies Act 2013 does not provide a formal one-line definition of a meeting. However, by analyzing its various provisions, the legal meanings can be derived. A meeting in the context of a company is a lawful assembly of 2 or more individuals who are members of the same body, maybe shareholders, maybe directors, for the purpose of transacting business of common interest to that body. So, every company, when it conducts the meetings, there are 2 types of businesses that are carried. One is general business, second is special business. So, we will be discussing about these 2 types of businesses also. So, what are the key legal aspects that define a company meeting under the Companies Act? Will include lawful assembly. Now, you see, when we say lawful, all the matters which are discussed should be in the interest of the company, because there will be a formal meeting. Okay. So, the meeting must be properly and legally called by a person or a body authorized to do so under the Act. That means whenever the people have to meet, there must be some kind of information passed to either the shareholders or the directors. For the shareholders, annual general meeting. For the directors, board meeting. So a notice must be given to the members or the directors sufficiently, then we call it as proper authority. Okay, now, and it is specified in the company's articles. So this means the meeting cannot be a casual or informal gathering. This is very, very essential to understand. Okay, and the meeting should be lawful assembly. And how many can attend? Two or more individuals. So in case of private company, how many directors will be there? Two directors, minimum two directors. In case of private company, how many directors will be there? Minimum three directors. So two or more individuals. Okay. For a meeting to be considered valid, there must be at least two people physically or virtually present. The common law rule of a meeting of minds requires more than one person to be present. An exception to this is in the case of one person company, okay, where a single member can hold a meeting and pass resolutions. So this is OPC, okay. Now, what does this members of the same body mean? The people attending the meeting must belong to the body for whom the meeting is being held. For example, shareholders meetings, board meetings, purpose of transacting business. So I told you, there are two types of businesses: ordinary business, special business. Now you see, the primary objective of the meeting is to discuss and decide on matters relating to company's administration and management. So there are two types of businesses undertaken. Under ordinary business, routine matters. What are the routine matters? Can anybody tell me now? What would be the routine matters? Now, directors' routine matters include approval of the financial statements, appointment of directors. In annual general meeting, directors are appointed in place of retired director, and appointment of auditors. So students, have you studied auditing subject or studying?
Sir, it's in the next semester.
Okay, you have not studied. Okay. So in the past, when 1956 Act was there, then the company can appoint auditors, but they may continue as auditors as long as the company directors feel or deem fit. Okay. So after Satyam Company's incident took place, a new rule is passed that the auditors are appointed every year. That means within 1 year period, whatever the job they have to do, they have to finish. If they are extending their service, they will know what they are doing relating to company, and there is every possibility of transferring the information to others also. How to commit fraud, how to give wrong statements, how to defraud. Okay, so all these are known to the auditors because each and every keen point is tested by the auditors. So these are the routine matters. Special business, any other matter that requires specific resolution, such as alteration of the company's memorandum or articles of association. We know company's memorandum will have certain clauses: name clause, objects clause, capital clause, liability clause, and subscription clause. Okay. So when we have these clauses, we can also alter. But which is the most complex form of altering the clause? Can anybody tell me? We can alter all other clauses except one. What is that? It's very difficult to alter. That also can be altered, but very difficult to alter. What is that? Can anybody answer? Anyone?
Sir, is it the AOA? Articles of Association?
No, in memorandum of association. I'm talking about memorandum of association. Who will give the answer? In memorandum of association, there is one task which is very difficult to alter by the directors. I gave you the clauses. One clause is name clause. Next is situation clause. Third one is capital clause. Fourth one is objects clause. Fifth one is liability clause. Last one is subscription clause. Which clause is more difficult or complex to alter? I am waiting. Who will answer? Shall I tell you?
Name clause.
No. Name clause can be altered by passing ordinary resolution and special. Very difficult to alter. Students, think and answer. There is an opportunity to answer.
Object clause?
Very good. Objects clause. I'm very happy. Okay. So objects clause is very difficult to alter. Why? There are two types of objectives. One is main objects. Second is other objects. Okay. We understood other objects can be altered from time to time. What about main objects? Now let us think about it. We started one company with the objective of building ships. Building ships. How many crores are required to build ships? Hundreds and hundreds. Yes or no? Okay. And if we want to construct a ship or make a ship which is very huge, carrying huge capacity, then it requires thousands and thousands of crores. We have started with a great objective. Now we could not do it. Permission by the central government is not obtained. Then we have to alter the objects of making ships into making films. Is making films easy or making ships is easy? Anyone? Nishita? Pravalika? So many are there. Okay. Making ships is very difficult than making films. You can make a small film, also make huge profits, like a recent Narsimha movie. Okay, Lord Narsimha's movie is released now, so that could make a huge amount of profit with a little amount of investment. But changing the objects of the company is very difficult. Okay, so we move to the next one. Requisites of a valid meeting. Every company will have to conduct the meetings, and we also call this as essentials of a valid meeting. Requisites or essentials of a valid meeting. The examination question may vary with these two words. Requisites of a valid meeting under the Companies Act 2013 includes that whether for any company meeting to be legally valid and for its decisions to be binding, it must adhere to a strict set of procedural and substantive requirements as laid down by the Companies Act 2013. and the secretarial standards issued by ICSI, Institute of Company Secretaries of India. Then what is the first and foremost requisite? Proper authority to convene. Who is the proper authority? Who can call a meeting? The meeting must be convened by a person or body legally authorized to do so. In case of general meetings, it is typically convened by board of directors. In case of extraordinary general meetings, it can be convened by the board on its own motion or on the requisition of the members. Extraordinary general meeting is conducted whenever there is a specific need. In certain cases, National Company Law Tribunal can also call a meeting. Now you see, the strength is increasing sentence by sentence. That means the board of directors may conduct the meeting, and if extraordinary general meeting is to be conducted, it may be convened by the board by a motion or on the requisition of the members. So there will be requisitionists. Who are the requisitionists? Creditors are the requisitionists. Creditors are also interested in the affairs of the company from time to time. So they may also call for a meeting. In certain cases, National Company Law Tribunal can also call a meeting when the nation's interest is questioned because of the operations of the company. Then Company Law Tribunal will call for a meeting immediately, and then actions will be taken against the people who are in the board of directors. Okay. Next, board meetings convened by any director, the chairman of the board, or the company secretary. Okay. So they are called proper authorities to convene the meeting. Then once the meeting is planned to be convened by the director or any person, there must be proper notice. While giving the notice, there must be clear days of notice to be given. The notice must be given for a specific duration as prescribed by the Act. For a general meeting, this is at least 21 clear days. Earlier it was 14 days. Now it is at least 21 clear days before the meeting. A shorter notice is permissible only with the consent of specified majority. Okay. So it is with a specified majority. Then to whom the notice must be given? The notice must be given to all persons entitled to receive it, which includes all the shareholders, every director, and auditors of the company. Okay. Now, I have one small question, students. So there will be meeting conducted. Directors will be attending the meeting. Auditor is also called. There is only one person who can directly walk into the board meeting without any permission. Who is that person? Can anybody answer? Company secretary. Okay. Company secretary can walk into the cabin of the board of directors. Permission is not essential, but permission is a formal thing. But without any kind of notice also he can go, and because he is very much interested about the affairs of the company. Now what should be the content? The notice must contain all essential details, including the day, Sunday, Monday, Tuesday, like that, the day, date, on which date the meeting is going to be held, time, from which time to which time the meeting is going to be held, and full address of the meeting. Generally, the meeting must be conducted wherever the registered office is located. In case there is any difficulty of conducting the meeting at a registered office, the board may choose to conduct the meeting at any place which is convenient to attend by all the persons like shareholders, directors, and auditors. Okay, na? So a clear statement of the business must be transacted at the meeting. So we were understanding ordinary business and special business. So what type of business we are going to transact, that statement should be clearly given. An explanatory statement for all special business to be transacted, which provides a detailed explanation of the proposed resolution. So these are the contents for the notice of the meeting. Okay. Sometimes notice may alone be asked for 4 marks. Next, proper quorum. Now, what is the meaning of quorum? Minimum number of members to be present. So minimum attendance. The meeting cannot proceed unless the minimum number of attendees required by the act is present throughout the meeting. So there are different types of meetings we were discussing. For a general meeting, as per section 103, the quorum varies for public companies based on the number of members. For a private company, the quorum is 2 members personally present. Okay. For a board meeting, as per section 174, the quorum is 1/3 of the total strength of the board or 2 directors, whichever is higher. Okay. Now we are discussing about public company. 3 directors minimum will be there. So what they are saying, 2 directors. That means 2/3 is present. Fine. So 2/3 is higher. Okay. And 1/3 of the total strength of the board. Now let us say there are 15 people. Then 5 is fine. 5 is more than 2 or not, like that. So for board meeting, the quorum is 1/3 of the total strength of the board or 2 directors, whichever is higher. Then lack of quorum. If a meeting lacks a quorum, it must be adjourned to the same day, same time, same place in the next week. If the adjourned meeting also lacks a quorum, the members present will constitute the quorum. So second time they see what are the number of members present. If the number is less, they can continue and understand that the members present is the quorum. Okay. So proper quorum may also be asked for 4 marks. Next is proper chairman. So chairman will be proceeding with the activities of the meeting. So he will be called as presiding officer. A meeting must have a validly appointed chairman to preside over the proceedings. What is the role? The chairman is responsible for ensuring the meeting is conducted in an orderly and a lawful manner. Orderly means whoever have to speak, whatever the documents that are to be put before for a discussion, all that should be in order. Okay, that is called orderly conducting and a lawful manner. Okay, so this is very, very crucial to understand. The chairman's decision on procedural matters are generally final. Then appointment of a chairman. The company's articles of association usually specify how the chairman is appointed. In absence of such provision, the members present at the meeting can elect a chairman. Okay? So this is one of the important area as to what are the essentials of a valid meeting, requisites of a valid meeting. Now, it also should have proper agenda and business to discuss. So we already understood there should be clear business that should be stated. The purpose for which the meeting is called must be stated in the notice. Ordinary business or special business. No new business. Generally, no business other than the specified in the notice can be discussed or transacted at the meeting. Suppose if we say special meeting, they cannot conduct ordinary meeting. What is that ordinary meeting? Anybody? What are we going to discuss in ordinary meeting? Ordinary business? Anyone? Approval of the financial statements. Okay, that is a routine. Okay, conducting the meetings, submitting the returns, reports. Okay, so other than that, if they mention in that notice, Other than that, they cannot discuss. Then transaction of business. The business must be transacted by passing a resolution, whether it is an ordinary resolution or special resolution as required by the Act. Then minutes. Whatever is being discussed in the meeting should be recorded, it should be accurate, it should be signed by the people, and there must be proper evidence that the people have attended. Okay, so these will be included in the meeting minutes of the meeting. Okay, next we will be discussing in detail as to what is the notice of the meeting. Notice of the meeting under the Companies Act is defined under section 101. Okay, now there is a statutory requirement. As we understood, it should have at least 21 clear days. What clear days means? Clear days means that the day on which notice is served, let us say today we have served this day, and the day of the meeting, the other day, both must be excluded from the 21 day count. Then there can be a shorter notice. So this is provision, actually N is missing. Provision to section 101 subsection 1. Sorry. A general meeting can be called with a shorter notice if the consent is given by, in case of annual general meeting, at least 95% of the members entitled to vote at the meeting. In case of any other general meeting, members holding not less than 95% of the paid up share capital carrying a right to vote. We have equity shareholders, preference shareholders. Okay, and manner of giving consent. The consent for a shorter notice must be given in writing or by electronic mode. To whom notice must be given? We understood. Members of the company, auditors of the company, directors of the company. So what are the businesses that we are going to discuss? We have already understood ordinary business and special business. Okay. So when we have discussed about the notice, what is the manner of giving the notice? It may be given in person by leaving it at the registered address of the person. That means if any person is going towards a particular location, a person may hand over that envelope or letter. So that can be called as notice in person. By post, so the information will be put in a envelope cover and sent it by ordinary post or registered post or speed post. Okay, now you tell me, when do we use ordinary post? My dear students, when do we use this ordinary post? Ordinary post is used when there are 21 clear days of notice. Then when do we use this registered post? Registered post is used in order to make sure that the notice of the meeting is received by the concerned shareholder, auditor, or the director. Speed post. Speed post is used when the matter is to be sent at a fast pace so that he will also attend the meeting by electronic means through mails, emails, SMS, and other electronic modes. Earlier, we had pages. It was like a small device. It was typed in a digital form. So in that form also, by electronic means, notice may be given. Okay. Defects in notice. Effect of omission or non-receipt. The accidental omission to give notice to or non-receipt of notice by any member, director, or auditor does not invalidate the proceedings of the meeting. If there is a deliberate omission, then the person who is responsible of serving the notice, he will be considered with a serious legal violation and can invalidate the meeting. Okay, na? Proxy. Okay. So what we do, we will end up here and we'll continue proxy in the next class. All right. Shall we close it here? Students?
Yes, sir.
So Varalakshmi is present. Varalakshmi?
సార్ తను ఇందాక వరకు ఉండే సార్ మధ్యలో నెట్వర్క్ ఆగిపోయిందని ఇందాక మీటింగ్ నుంచి వెళ్ళిపోయింది ఇప్పటిదాకా ఉండే అది నెట్వర్క్
అవునా?
వల్ల
సరే.
ప్రాబ్లం వచ్చి పోయింది సార్ వర్షం
Okay.
పడింది ఇప్పుడు
అయ్యో ఎక్కడ పడుతోంది
అవును
వర్షం?
అదే
సరే.
పోయింది
It's
దాని
okay.
నెట్
ఓకే సరే పర్వాలేదు. సో నాకు ఈ వీళ్ళ రోల్ నెంబర్స్ తెలియదు కాబట్టి జస్ట్ పోస్ట్ ద రోల్ నెంబర్స్.
ఓకే సార్ సరే ఇందాక అది ఆల్రెడీ చేసేసింది సార్ గ్రూప్ లోనే ఉంది
ఉందా? ఓకే డన్ దెన్.
ఆల్రెడీ చేసేసింది
Okay. So
Okay,
we'll
sir.
end up the class here. Thank you so
Okay,
much.
sir.
We'll meet on Monday.
థ్యాంక్ యూ సార్ థ్యాంక్ యూ సో మచ్
Right,
Thank you,
right.
sir.
Yeah, welcome, welcome. Right.
Thank you, sir.
Welcome.